Welcome back to the courtroom, where the tension is already sky high. Today, we are diving into the case of State of Texas versus Cameron Sell. On the surface, it looks like just another criminal proceeding, but don't be fooled, this case carries massive weight. Cameron is facing aggravated assault against a public servant, a first-degree felony that carries a possible sentence of life in prison. Yes, you heard that right, life. And yet, here we are, hearing talk of a plea deal and the possibility of deferred adjudication. How does someone accused of such a serious crime end up with that option? That's exactly what we are going to break down. We'll follow the twists, the legal nuances, and the judge's final ruling. Along the way, I'll ask you, the jury of public opinion, what you would have done in the judge's shoes. Buckle up, because this one's about to get dramatic.
Court is calling 2022 CR 5615, State of Texas versus Cameron Sell. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Daniel Navy.
Right. And probation, this is an application. And are you Mr. Sell? Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Mr. Sell, I'm showing you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Okay. You're charged with aggravated.
This is an important moment. The judge is laying out the foundation of what a plea bargain means. Notice how carefully she explains that the court doesn't have to honor the agreement between the state and defense. This is a safeguard. The defendant needs to fully understand that if the judge feels the deal is too lenient, she can reject it and impose a harsher sentence. Think about it. Would you take a deal knowing that the judge could still change the terms? Or would you roll the dice and take your chances at trial?
Assault against a public servant in count one, that's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement you were giving up those rights?
Now here's where things get serious. The judge confirms an affirmative finding of a deadly weapon. That phrase isn't just courtroom jargon. It has major consequences. It means Cameron will carry a record stating he used a deadly weapon, even if he avoids prison today. That designation follows him forever, affecting jobs, housing, and future sentencing. It's a scarlet letter in the justice system. So here's the real question. Is deferred adjudication enough accountability when we're talking about aggravated assault with a deadly weapon against a public servant?
Do you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I believe it does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe that, Your Honor.
Mr. Sell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, state is proceeding on count one. There's a $1,000 fine. Affirmative finding of deadly.
This part often slips by viewers, but it's huge, the waiver of appeal. By signing this, Cameron is basically saying, whatever happens in this deal, I won't challenge it later. It slams the door shut on appeals unless something was mishandled in a pretrial motion. In plain English, once this gavel drops, Cameron is locked into this outcome. Do you think it's fair to take away someone's appeal rights in exchange for a deal, or is it a necessary step to keep the system moving?
Weapon, and the state recommends deferred adjudication. Do you understand that to be the plea?
Yes, Your Honor. And just my understanding is that if he was to get deferred adjudication, deadly weapon finding would be deferred as well in order to receive the deferred adjudication.
I mean, there's still going to be a finding, an affirmative finding of a deadly weapon, but he'll get the deferred adjudication if I follow the plea.
Okay.
All right. All right. State, is that the plea?
Yes, Judge.
Defense?
Yes, Your Honor.
And did you understand that to be the plea? All right. And I see there's a case number that's been marked through. Has that case already been taken care of?
It will be, Judge, but it's not.
This is a fascinating moment in legal strategy. Instead of calling live witnesses, the state submits written testimony and reports. By agreeing to stipulations, Cameron avoids a public airing of all the gritty details in open court. No cross-examination, no surprises, just documents. From the defense's perspective, this can minimize damage. But for us watching, it raises a question. Should cases this serious be handled without live witness testimony, or is efficiency more important than transparency?
Not part of the plea agreement.
Okay. All right. Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor. Well, there was a motion to set aside the indictment, but just one, I guess.
All right. And are you waiving that motion?
Yes, Judge.
Next, I'm showing you outside the agreement. The state is requesting that your deferred adjudication be for a term of 10 years. There'll be a TAP evaluation, 200 hours of community service restitution, the MRT, and defensive driving. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense is charged in count one. How do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Judge. State out for State's Exhibit 1 and its attachments.
No objection.
Mr. Sale, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
Here comes the defense's strategy, humanizing Cameron. They present an apology letter and stack of psychological records. Anxiety, depression, ADHD, oppositional defiance disorder. The defense wants the court to see not just the crime, but the person behind it. It's a classic mitigation play. Don't see him as a violent criminal. See him as a troubled young man who needs treatment, not prison. Do you buy this argument, or do you think personal struggles shouldn't excuse violent acts?
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty if you apply for deferred adjudication. Are you proceeding with sentencing?
We're fine proceeding with sentencing, Judge.
Anything you wish to say on behalf of your client?
Judge, I'd just like to offer defendants exhibits 1 through 6, and I've showed them to the state.
Any objections?
No, Your Honor.
And Judge, what those are, number one is an apology letter.
This is one of my favorite moments, the judge cutting through the excuses. She asks the most basic question, do you have a job? Cameron admits he doesn't, saying stress held him back. But the judge isn't buying it. Notice her pushback, you need to work or go to school. This is accountability in action. It shows the court isn't just punishing, it's demanding responsibility. What do you think? Should judges take this tough love approach with young offenders, or is it too harsh?
The police officers. Exhibits 2 through 5 are various psychiatric, psychological, and counseling records indicating some of his various mental health issues that he's been dealing with in his young adult life. He's been diagnosed with anxiety, depression, ADD, ADHD, opposition and defiance disorder. He hasn't been diagnosed with autism, but it hasn't been ruled out. And some of the psychiatrists believe that he needs further testing to see if that's something that He was dealing with Judge. He's a young man. I believe you're 19, 18. He's had no violations on his pretrial monitor judge. He's never been arrested before. He finished his high school diploma. That's Defendant's Exhibit 6 that you have. And we would ask that you follow the plea bargain agreement.
All right. So are you working? What are you doing with your life?
The sentencing conditions are piling up: anger management, defensive driving, community service, and even incentives tied to education and COVID vaccinations. This is rehabilitation-focused sentencing at its peak. Instead of locking him away, the court is setting hoops for Cameron to jump through, some tough, some unusual. What's interesting here is the creativity, reducing service hours if he goes to school or gets vaccinated. Do you think these kinds of conditions actually help reform someone, or do they just add layers of stress?
Right now.
I can admit I kind of made it hard on myself with this. I kind of told myself, hey, since you got this, it's kind of hard to get a job. So while being on this, I really haven't put too much time in trying to do that because I've been so stressed and talking myself down, I guess.
You need to get a job.
Yes. So I actually have a buddy who just got offered a job recently, and he's going to see if they can get me up in there as well.
Doing what?
Just working at a gas station. Yeah.
Okay. All right. I don't understand the request for defensive driving.
Because of the facts of the discharge.
And
But I'm sort of like, if somebody's,
I think this may resolve the issue, Judge. He did complete a defensive driving course recently. And so I would ask that he just get credit for that if he shows probation, the certificate.
all right.
He did complete that.
10 years deferred adjudication, defensive driving. There's $1,000 fine that will be probated. Do you have any children? Right. Anger management.
Oh,
No, I mean, I'm assigning.
Listen closely, the judge is crystal clear. No drugs, no unsupervised contact with minors, proof of employment, field visits twice a month. She even spells out that Cameron can't just coast at home with his mom unless he's in school or working. This is where probation turns from a lifeline into a microscope. The judge is saying, you want a second chance. Prove you can live like a responsible adult. If it were you, would this motivate you to change, or feel like you're walking on eggshells every single day?
Anger management
okay. You're
courses.
asking questions, sorry, Judge.
And that's based upon the exhibits that's been presented to the court. There's an affirmative finding of a deadly weapon. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. The remaining hours will be waived if you enroll in some higher level of education. If it's college, I will tell you, are required to be full-time. So if you plan on enrolling to college, the court will not waive the remaining of the community service hours unless you are taking at least 9 hours per semester, or if you are in a trade school and obtain a certificate. There's to be regular reporting, regular UAs. If you're drug tested today, what are the results going to be? What are you going to be positive for? And what else? All right. Marijuana is not allowed.
The judge brings up MRT, moral recognition therapy. It might sound fancy, but at its core, it's a program teaching empathy and responsibility. Treat others the way you want to be treated. It's almost kindergarten ethics, but for adults who miss the lesson. The judge's tone here is sharp, like she's saying, you should already know this. But this highlights an important issue. When the basics of morality break down, sometimes the court system itself has to teach them. What do you think? Is it sad or hopeful that a criminal court has to play teacher?
You understand? We're going to do the testing for levels. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. They want you to do the MRT. The MRT course is telling you that you need to consider others in your action.
And there it is, the gavel drops on Cameron Sell's case. Instead of decades behind bars, he walks out with 10 years of deferred adjudication, strict probation terms, and a long list of conditions. On one hand, it's a second chance for a young man with no prior record, bolstered by mental health struggles. On the other, it's a high-stakes gamble by the court. If he slips up, he could face life in prison. So, what do you think? Justice served or too much leniency? Let us know in the comments below. And if you found this breakdown as eye-opening as we did, hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom commentary. Until next time, stay sharp, stay curious, and we'll see you in the next trial.
It's something that people should learn in kindergarten or preschool. Be nice to everybody. Treat others as you would want to be treated. But you're going to take the course. I'm going to want field visits 2 times per month. Who do you live with?
Father.
All right.
And father.
So here's the thing. You're either going to have a job while you live with your mom, or either you're going to be in school. I don't allow people who are adults to live at home unless they're working or either they're in school at your age. You understand? All right. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court in order to be successful? Show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?